Well, good morning, everybody. Thank you all for making it. For those of you who braved the weather, we appreciate it. It's good to see faces. It's good to be back in person now after so long. We've been doing these remotely, obviously, for the last few years. So we always prefer being in front of a live audience and to get feedback. We also have hundreds, maybe thousands of people listening remotely as well right now. So I think they're only getting audio, but hopefully that's going to work out smoothly. We don't have technical difficulties. If anyone has any problems remotely, reach out to Ramona and we can get that resolved. We are, for those of you who are attending in person, you can reach over here and make sure you grab your MCLE forms or HRCI forms. If you haven't done so already, make sure you get credit for this. For those of you who are attending online, an e-blast went out before, I believe approximately an hour to half an hour before the seminar. And you should have received a copy of the presentation, a PDF of all the slides we're going to be going through today, as well as information on how to request your HRCI MCLE credits. And for those of you who registered late yesterday or this morning, the second e-blast will be sent following the presentation with a link to the recording of this webinar. So you can watch it and rewatch it again and again and again to make sure you've got all the wonderful morsels of information you're going to learn today. That e-blast will also include links to our L&E law blog that we have going on for many years. You can go back and look at cases and updates that we've blogged about. In addition, this last year we started I can't remember what's called the California Employment basically news. It's called California Employment News, right? Yeah, it's a great name. And that's our video blog that we have that we again has been hit with, critics are loving it. It's huge. So make sure you take a look at that if you want to have a different way to listen or watch other than just reading these updates. So as far as questions, everyone feel free. Everyone who's live, raise your hand and we can always field questions in real time. For those of you remote, unfortunately, we've disabled some of the chat and raise hand functions. But you should be able to still, and we invite you, if you have questions, to leave those questions in the Q&A queue, and then we'll address those hopefully either during the presentation if possible, but hopefully definitely at the end if we have time, which I'm not promising, I never am, because you know how these things go sometimes. So with that, I won't take any more of our time, and we'll start with the content today. And as you know, and just so you know, we also have more content at our next webinar, part 2. And Ramona, when is that again? January, when is it? 18th. So on the 18th, you should come over and listen to that as well for those who are attending and haven't signed up for that one. And before I start, I want to introduce all of our presenters today. So here we have all the way from San Francisco, Shauna Correa, who is our shareholder here in our San Francisco office. We're all in the L&E department here, obviously. And then Rachel Davey, who's here from San Francisco as well. Again, they've braved the weather. How many floods and did you drive through?
At least 3 natural disasters.
3 natural disasters, ground freeze. So it's amazing they made it here on time. And then Nikki Mamadi, who's here in our office here in Sacramento. We're all excited to present to you today on our subject. So you'll hear from all of us. And you'll hear from the rest of our department for those of you who come to the January 18th presentation. Okay. So I didn't realize how I'm going to click this thing. There we go. Oh, look at that. Unbelievable. Okay. So these are some of the subjects we're going to be going through today. So there's been some big developments this year. And as you know, we're going to go through some of the statutory developments that have happened, some of the agency regulations that have changed, as well as, obviously court cases that have developed some of these areas that we'll walk throughout this last year. I'm going to start, we're going to go over class action and PAGA claims, some of the developments in law there. So the big one that a lot of you have probably heard about is Viking River Cruises, Inc. versus Moriana. So this was kind of a sea change case for employers. It's one of these rare instances where the employers, it was a big benefit to employers for purposes of PAGA claims and how to kind of nip in the bud some of these really expensive PAGA claims. We'll go into what these mean exactly. But to lay the groundwork, I want to understand exactly why, because this is a little technical, and bear with me. But the Federal Arbitration Act, all of these cases revolve around what's called the Federal Arbitration Act, the FAA. And what that was is the federal government instituted this act, the FAA, way back. And what it said is state courts, and state legislators, they can't create any law or policy that makes it more difficult to enforce arbitration agreement as it would a normal contract. So basically treat them like contract. You can't create special rules to not enforce these arbitration agreements. And obviously employers want to do that so they can handle these cases more efficiently. And when it comes to class actions, you can actually get those class actions dismissed because we have an agreement to arbitrate all of our disputes individually, right? Mano a mano. You can have your disputes. You're not waiving your rights to disputes, but all your disputes are going to be handled by a private arbitrator, not in a court, okay? And those are considered contracts, but a lot of states, and especially California, typically want to do is to find ways to find these things unenforceable, right? To bring them to court and to allow employees to bring class action claims. So in arbitration agreements, they often have either explicitly or implicitly class action waiver. Again, our disputes are in mano a mano, but if you bring it, you can't bring a class or collective claim representing or to represent other employees other than yourself. And in the typical result for these is the employee files a class action claim. The employer then files a motion to compel the arbitration agreement and to dismiss the class claims. Okay, and if everything works out, everything checks out, that's the way it would typically go. But PAGA is peculiar. PAGA is this kind of weird mutant, right? Where it's what's called it's a qui tam action. It's kind of a quasi-class action. And it's the PAGA is a Private Attorney General Act. What it allows is employees to step in the shoes of basically the state, to act as the private attorney general, to seek after penalties against employers on behalf of the state. So you can't get wages, it's just penalties, okay? So because of that, courts have typically viewed them as different than a class action for purposes of arbitration agreement because the state has no agreement to arbitrate with the employers, right? So to the extent the employers are stepping into the shoes of the state, there's no arbitration agreement at all. And that's the way courts kind of were viewing it up until this case we'll talk about. So Viking River Cruise, this is published in this year. The U.S. Supreme Court held that PAGA representative action waivers can be enforceable. Again, this is a huge sea change. We litigate in this office all the time, this issue, right? Because you want to go in there, you want to prevent this type of loss. And so this was huge for employers. So what Viking River Cruise has held, and again, this is where it gets a little technical, that PAGA encompasses two types of representation. So the first one is qui tam. And qui tam, like I said, a qui tam action is an annoying Latin phrase that just means you're pursuing this on behalf of the state, okay? And there's a lot of things like that. PAGA is one version of it. There's other types of claims you can bring that are similar to this. But the first type of a PAGA representative action is qui tam on behalf of the state for the employee's own claims. They're saying the second part is the representative claims. So you're representing these employees. So the most important, I think, or most significant holding here from the Viking River Cruise case is that the FAA preempts Ascanian's rule against forced claim joinder. Ascanian was a California case that basically was the start of this. You can't arbitrate PAGA claims, and you can't dismiss PAGA claims through an arbitration agreement. So again, what this said is it preempt the Ascanian's rule against what's called forced claim joinder, meaning you have the individual claims and the representative claims, and they have to stay together. They're inseparable. What this court says, you can separate them. You can't require them. So the arbitration agreement still has to say that, but if it does, then those claims can be separated. And so now courts can divide the PAGA action into individual and non-individual claims through an agreement to arbitrate, and that's now permissible. And in that instance, the individual PAGA claim will go to arbitration. But then the big question, which we're going to talk about now, is what happens to the representative claims, right? And so the FAA does not preempt a bar on wholesale waivers of PAGA standing. So that's it. So what they had in this case was, what they determined was that there's no, once you remove your individual claim from the collective PAGA claim, there's no standing to sue. You don't represent the employers because you're not one of them. You kind of have your own individual issues being arbitrated. You don't represent the rest of the employees. So the question then becomes, do they have standing to even pursue that? And how do we treat these? Do we dismiss these claims? Do we allow them to pursue in what form? What happens to the collective part of the PAGA action? And that's kind of the open issue here that's left. And the dissent in the Viking River, what they said was that standing is a state court issue, that the California legislature can modify the scope of statutory standing. Excuse me. And that's what a lot of us have been waiting on. Is okay, what's the legislature going to say, if anything, on this? Add some clarity. A lot of courts are kind of on this holding pattern, waiting for instruction on how to handle these things. And it's kind of yet to be clarified until Adolph. There's a case Adolph, this is versus Uber Technologies. That's currently under review. And we're checking it every day to see when it's going to come out. But basically, they're going to take a stab at trying to understand what this entails and how to handle the standing issue. Again, what some courts are doing is they're dismissing them. They're saying there's no standings to dismiss them. And a lot of other cases are kind of staying this issue pending Uber. Okay, well, that was really exciting, wasn't it? Now we're going to talk about waiver. Okay, so waiver is a contractual thing. I mentioned the FAA, right? Remember the rule for FAA? Courts have to treat arbitration agreements like they do all other contracts. So under contract law, generally, you have waiver, right? You can waive your contractual rights under certain circumstances. Okay, so in this case, Morgan versus Sundance Inc., after nearly 8 months delay in filing a motion to compel arbitration, it did not result in waiver. So the FAA, basically what the court said is what they typically do, what courts have done, and we've again litigated this many times, is they look at what's called the impact it has on the party that the other party is trying to enforce the arbitration agreement, is typically the employer. They look at what prejudice that delay caused the employee, right? You incur all these litigation costs. Why didn't you file the motion to compel arbitration right at the outset of the case? Why did you let us engage in discovery? Why did these things happen before you filed, right? And in the contract, you'd say, well, you waived your right. You acted kind of against your right to arbitrate, and so you've waived that, right? And there's some court rules that said they look at the prejudice of that. And in Morgan, again, the ruling here was the FAA does not authorize courts to create an arbitration-specific procedure requiring a finding of harm, prejudice before a party could waive its right to arbitration. So in this case, the base of the finding was courts can't also favor arbitration, right? So it's kind of has to be neutral arbitration. Doesn't mean they can't make rules to favor or disfavor it. And that's what I won't go into quack yet, but that's kind of the same thing here. You can look at this again. Everyone should have these. For sake of time, I'm not going to go into depth on every single one of these cases. But another issue is that's developed this year is what's considered interstate worker under the FAA. So under the FAA, it exempts employees that are considered interstate workers, a worker engaged in interstate commerce. And in this case by Southwest Airlines, a ramp supervisor who was kind of engaged, right? You're kind of engaged in interstate commerce if you're a ramp worker. They frequently loaded and unloaded cargo on and off planes. And that was considered a class of workers engaged in foreign or interstate commerce that was exempted from the FAA's coverage, okay? But it expressly didn't cover all types of employment, of airline employees. So it's gonna be very specific as to what's considered interstate workers. So within your business, you might have classes of employees that are engaged in interstate commerce. It's not gonna be a business-wide analysis. They're gonna look at each individual, position. And they said wouldn't necessarily cover shift schedulers or website designers. Those folks aren't necessarily as directly engaged as were in this case, the ramp supervisor. But this did leave a lot of issues kind of open for to be determined later on. AB 51, a lot of us remember this. This was a bill that was passed back in pre-2020. And what this did is it precluded employers from requiring employees to sign an arbitration agreement as a condition of employment. So what it said was, it kind of left open, maybe you can have them voluntarily sign it, right? But if you present an arbitration agreement to an employee before they're hired or to an applicant, and they say, I'm not going to sign this. They're saying you can't say, I won't hire you then, right? You're making it a condition of employment. And under AB 51, that would be illegal. That would be a violation of the law if an employer was to do that. Because again, I want to be able to, I don't want a big class action, a bunch of employees that haven't signed arbitration agreements. But that's, so AB 51, so go back to FAA, does this violate the FAA, right? You're kind of adding a special law that affects arbitration agreements, some might say. So in January 31st, 2020, in our very own Eastern District, a few blocks this way, Judge Mueller granted a preliminary injunction directing the state not to enforce AB 51 on the grounds that she expected that this thing would be found to violate the FAA. But in 2021, a divided Ninth Circuit panel held that the FAA doesn't completely preempt AB 51 as it regulates pre-employment contracting. So it's before the employment. This is applicants, right? It's like, well, it's, you know, we think it falls outside of it. Again, you see a lot of courts doing all they can to not enforce these things. Then the U.S. Chamber of Commerce, they filed a petition after Viking River that we just went through, which again, reiterated to the country and usually pointed directly to the Ninth Circuit that, you know, these things need to be enforced. And then because of that, on August 22nd, 2022, the Ninth Circuit decided to withdraw its prior opinion and granted a panel rehearing on this issue. So again, in flux still. 2022 was we have a lot of questions, but it seems like this is something that could be going in the employer's direction again, in favor of enforcement of arbitration agreements. But TBD on that one as well. The other issue is PAGA manageability. So when you have a class action, one of the big determinations as to whether the class can be certified to proceed as a class is whether it's even manageable, right? So they look at, like, do you have the same type of, do you have a common interest associated with the group where the violations look the same? Like, can we manage this as a class? Will this require thousands of individual trials to determine, for instance, did you clock in different than you? You know, or is this something we could treat as one kind of single violation the employer did in a single way? And for class action, that's required. In fact, the plaintiff's attorney has to prove that it's manageable. But for PAGA claims, there has been no manageability requirement. So you can bring a PAGA claim, you don't have to show that, you don't have to prove that, right? That's kind of the way it's been. In 2021, Wesson versus Staples, the employee misclassification case, the trial court determined that PAGA claims unmanageable as it would require a years-long trial of the claims as pled because individual issues predominate. So again, in this case, they said that, look, in a PAGA case, we can actually determine manageability. Because think about it, like in order to ascertain whether there's a violation here, as a matter of reality, we're gonna have to interview and depose and eventually present to trial all these witnesses, and it will take years, you know, to determine whether there was. Without, you know, if we really want to have due process applied here, that's what's going to be required. And the court said, this is unmanageable. We can't do this. So we're not going to allow this to proceed. We're going to dismiss the PAGA claims on that ground. Okay, then Estrada. This is a case that happened last year. It was published last year, and it held that PAGA has no manageability requirement like a class action. So no grounds to strike. And they said that Wesson was an error. So you have a split authority here. Okay, so California Supreme Court granted review of this split, and they're going to address it. So again, TBD. 2023 is going to be a great year for us to learn a lot about how to run our businesses, right? But yeah, so this is something, and again, think about the implications this has, right? Because for class actions, for those of you unfortunate enough to have gone through a class action, as you may know, the certification stage is the most important stage of a class action typically. You know, if you can prevent certification, the class action is dead, right? That's before you even found the merits. So that's kind of, it'll give a similar opportunity for employers here within the PAGA context when you look at the manageability of those. Okay, in this PAGA's exclusive concurrent jurisdiction, in short, this case, Shaw, that was published again last year, there was someone brought a PAGA claim in one jurisdiction, and then the employer was operating in other jurisdictions. Another employee brought a PAGA jurisdiction too, or a PAGA claim as well. So you have two claims arguing the same set of issues for the same, purportedly for the same group of aggrieved employees. So the question is, what do? You know, typically when you have a lawsuit in a class action, you have exclusive jurisdiction. Usually it's first to the line, right? Whoever filed first, then they'll join them or dismiss one. Or in this case, the court found that PAGA should be treated the same way. So what they do is they stay the action of the late filed case, and the early one gets to proceed. So again, preserving judicial resources. How does that make sense? To have two cases that potential different rulings from a court on the same set of issues. So this is a kind of a common sense ruling. But again, PAGA is kind of a new creation, so we're realizing this. But this was, I'd say, a good ruling from the Superior Courts recently. So with that, I'm going to turn the time over now to Shauna, who's going to tell us about independent contractors.
All righty, Brian. All right, let's make sure I know how to operate this device. Okay. All right, so I'm going to talk about a case that might not start out sounding like it has anything to do with independent contractors. So this case involved a person who was a photography model who was hired by Walmart to do some photo shoots and appear in some, print ads. And so Bijan Hill appeared in 10 photo shoots on various days, not all consecutive, in 1 to 2 day periods. So there's a total of 15 days over the course of a year. And when the contract was up, and when the person was done working, they hadn't been paid timely under their understanding of their relationship with Walmart, which they took the position they were an employee. And so they sued for $500,000 in waiting time penalties under the labor code, which says that you have to provide someone their final paycheck either the day that you terminate them or within 72 hours of notice. And the $500,000 figure is whatever their daily rate, and I didn't do the math on this, but whatever their daily rate is times 30 calendar days. And so they were making a nice daily rate as this photography model. And so they said, well, you didn't pay me at the time it was owed, and so therefore I'm owed all these waiting time penalties. Well, Walmart said, well, wait a second, you're not an employee, you're an independent contractor. And so there are no waiting time penalties owed. And so this went up to the Court of Appeal. So there was a summary judgment motion brought on the grounds that this person was not entitled to waiting time penalties if they were not an employee, if they were an independent contractor, because the labor code only applies to wages, not just any payment of money to just any old person. So, unfortunately, if you don't pay our legal bills in time, we don't get to, go after you for waiting time. So the court said, okay, no, there's a triable issue of fact, but the court couldn't decide on the facts that it had before it, whether this person was an employee or an independent contractor. But the court said, well, Labor Code Section 203 is only for willful violations, and when there is a good faith dispute about whether or not the wages are owed, then waiting time penalties don't apply to the disputed amount of wages. And so the court said summary judgment should be granted. So then, and by the way, all this happened back in 2017, which was before AB 5, which we all talked about ad nauseum for the last couple of years. So what happened though kind of further was that then this went up to a Court of Appeal, and the panel basically said, the argument that the plaintiff made, that the employee made was, well, Walmart can't make the argument that there's a good faith defense because they misclassified me. I was misclassified as an independent contractor. And so this was pre-85. And so the court said, well, we will look at this under the Borello factors. And the Borello factors, as you might all be familiar with, was the test that we used to determine independent contractor status for most things, right? For a number of years before the ABC test came out. And it has all these factors with the right to control and who bought their equipment and who, made the schedule and all of those things. And the court said, well, Walmart, based on the evidence it presented, did have at least a good faith basis to dispute whether they were an independent contractor or an employee. And even though the plaintiff in that case did put forth some evidence that Walmart exercised significant control over what she did as a model. I'm sure they told her exactly how to stand. I'm not a model, so we're trying to pose like one. She paid for and arranged for her own travel. She didn't get paid on a W-2. She was paid on a 1099. She also provided modeling services for other companies, so she wasn't captive. she did other jobs in between these photo shoots with Walmart. So they said, okay, Walmart, you had a good faith belief that this person was not an employee. And so consequently, there was reasonable grounds for Walmart to say, I think you're an independent contractor. Now the parties were free to then go litigate that issue. And they were free to, fight that out, duke it back out at the trial court, at some other juncture, but waiting time penalties were not owed. And so the good thing about this is for employers, obviously, if you have somebody who you've classified as an independent contractor and you think based on the applicable test, in this case, they applied Borello, but most of your situations, it's going to be the ABC test, the new test under AB5. There are some exceptions for various types of positions and they have different tests. But if you look at all those factors and you have a good argument, essentially, that this person is an independent contractor, you don't have to worry under this case about being hit with waiting time penalties because you had a good faith basis for a dispute. Now, does this mean that you should just misclassify everybody? Oh, no. Does this mean that we should claim that we have a good faith dispute with somebody who is obviously an employee? No, of course not. So, this isn't an argument we would, cook up after the fact, after treating this person as an employee. So if you have somebody who you're letting go, that's an independent contractor, one of the things that, I always want to make sure that we do is think about how you would rephrase that with any vendor. And if you're dealing with an independent contractor that's an individual, you're not firing them, you're ending the contract, make sure that the words that you use don't give them any arguments to claim that they were your employee. And so, of course, call us if you have any doubts, but the good news here is a case in favor of the employer. If there's even a good faith dispute that they're an independent contractor, then they didn't owe the waiting time penalties. So most of the time they're not in that level of 500,000, but they can add up very quickly. Okay, so who is up next talking about independent, non-exempt employees? Rachel. All right. And I will be back later to talk to you about employee privacy rights. I know you're excited. There you go. Push down to your next slide. Okay.
All right, good morning, everyone. Here we are going to be talking about non-exempt employees. And just as a refresher, the difference between exempt employees and non-exempt employees, for most of our purposes, are that non-exempt employees are usually hourly workers and are not exempt from rest and meal breaks, for example. So here we go. All right, first we are talking about SB 1334, which is meal and rest periods for public health employees. This is for employees who provide direct patient care in a general acute care hospital for public sector employees. These individuals are now entitled to meal and rest breaks. They previously were not. And in the next slide, this explains kind of the breakdown of the meal and rest periods to which they're entitled. These are the exact same as for ordinary non-exempt employees. And like ordinary non-exempt employees, meal periods can be waived, but employers can require on-duty meal periods. So the key there is also knowing whether or not you need signed waivers and how to handle those. And we can always assist you with that. If you're wondering, does this apply to me? Am I this public sector hospital? Do I employ these types of employees? You can ask us and we can provide you with a case-by-case analysis. And then the last note is that this does not apply if the employees are covered by a collective bargaining agreement, also known as CBA. This is very important. A lot of nurses, people of this sort who work for these public hospitals are covered by CBAs. They are in unions. So if they're covered by a CBA, this doesn't apply. Next, we are talking about AB 984, the fleet motor vehicle tracking. First thing to note is that this law impacts only the use of, quote, alternative devices to track employees in fleet vehicles. This does not impact existing laws on GPS tracking. So it gives kind of an example. Let's see. And so things that employers could track include locating, tracking, watching, listening to, or other surveillance of the employee. And this law states that employers can only monitor employees via alternative devices if, one, it's during work hours, and two, it's strictly necessary. Now, the statute does not define what strictly necessary means. If anyone here could provide a definition, that would be great. We don't know what it is yet, but that is probably where we anticipate the litigation will arise, given that lack of clarity. And this slide just explains that if you are going to track your employees using these alternative devices, and the two elements that we just discussed are there, then notices are required prior to tracking the employees. You can't just, track them without them. And the notices have certain requirements, and we included a lot of them here. And that is pretty much it for the fleet motor vehicle tracking. Next, we have California AB 257, which is the Fast Recovery Act. This applies to many fast food restaurants, and this act states that through 2028, it creates a council that is able to establish sector-wide minimum wages, hours, health and safety standards, and cost of living standards. Now, this council is appointed by the governor, and they, in theory, can do all these things. There's been talk about a significant increase in minimum wages, for example. That is one of the issues with this act. Then this slide explains that, as you can imagine, there's already an effort to pass a new law invalidating this one. And this law is currently enjoined from going into effect by a California appellate court. So if you're wondering, does this law affect my restaurant business? You can come talk to us and we can assist you. However, do know that at least for now, it's enjoined. Next up, we have SB 951 regarding calculating SDI and PFL. So here, this is so specific and determined on a case-by-case basis according to how much an individual employee earns, where they live, where they work. That best thing to do in this scenario is, if you have any questions about the updates to how you calculate SDI and PFL, contact us and we can help you on a case-by-case basis. Naranjo versus Spectrum Security Services Incorporated. Throughout this entire year, this is the most important case to come out for non-exempt employees, because when non-exempt employees, like I mentioned before, are entitled to rest and meal breaks. When they do not receive those rest and meal breaks, they are entitled to 1 hour of premium pay per day for the rest or meal break missed. So what do you do with these premium payments? Are they just, extra money? Do they count as wages? Well, Naranjo held that that premium payment counts as wages. And because it is a wage, it has to be on the wage statement. And it also must be paid by the employee's termination, or the employee can come back and seek waiting time penalties for failure to pay that wage. So that's very important. We always like to iterate to our clients, make sure you're keeping track, clocking in and clocking out at exact times, and make sure that your non-exempt employees get their full rest and meal breaks. so that we can hopefully avoid these situations. Then we have Espinoza versus Hepta Run. This case basically just applies to short haul drivers. So if you're an employer of short haul drivers, this case is very important to you. In 2021, the Ninth Circuit held that the FMCA, which is the Federal Motor Carrier Safety Administration, rules preempt the California rest and meal period rules. And that was with respect to essentially long haul drivers. This case came up because the plaintiff said, I'm a short haul driver. I'm the exception to the rule. And the court said, you're not an exception to the rule. The FMCA preempts meal and rest breaks for you too. So this was a win for employers. And then the last case we have here, Meza versus Pacific Bell Telephone Co. This is where additional overtime is owed to employees on the basis of performance bonuses. So the employer was just adding in these lump sum payments to make up for, oh, we needed to pay you extra overtime because of this performance bonus you got. And an employee sued saying this violates California Labor Code 226, which is the wage statement requirements, because you don't list the hours and wages, the hours and wages I worked. And the court held, no, that's not true. The employer does not need to list rate and hour information related to these true up payments on wage statement. So another one for employers there. And now we will be discussing exempt employee status with Nikki Mamundi.
Hello. So we're going to talk about exempt employee status. There's not much that is going on here, but there are a few things worth noting. So there has been an increase in California minimum exempt salaries effective January 1st, 2023. So the minimum salary threshold for exempt executive, administrative, and professional employees has increased to $64,480 per year. Similarly, with computer professionals, there are certain computer professionals who are exempt from overtime pay if particular criteria are met. So one of the criteria that's included is the employee's rate of pay cannot be less than the statutory specified rates. And so here, the minimum rate of pay applicable to these professionals has increased to $53.80 per hour, $9,338.78 per month, and $112,065.20 per year. Similarly, with licensed physicians and surgeons, there are certain licensed physicians and surgeons who are exempt from overtime requirements if certain criteria are met. And one is being that a minimum hourly rate of pay is met. Here, the minimum hourly rate of pay has increased to $97.99 per hour. In terms of case law, there's not much case law that's come out, but there is one case, Rodriguez versus Paribar, Inc. Now, this isn't something that employers are going to have to consider in their daily practices, but it is something you want to consider when defending misclassification suits. So misclassification suit would be where an employee comes and says that, I was misclassified as an exempt employee when actually I was a non-exempt employee. So here, the plaintiff was a jack-in-the-box manager, and she alleged that she was misclassified as an exempt employee and entitled to overtime wages and meal and rest breaks. But the employer contended that no, she was properly classified as an exempt employee under the executive exemption. And so to meet that executive exemption in this case, there are 6 prongs that would have to have been met. And one of the prongs was that the employee is primarily engaged in duties which meet the test of the exemption. And this consists of examining the work actually performed by the employee during the course of the work week, the amount of time the employee spent on such work, along with the employer's realistic expectations and the realistic requirements of the job. And at trial, basically, the jury was given a special verdict form, which is basically a form requiring juries to make written findings on issues of fact. And there's one ultimate fact question going back to one of the prongs of the 6 prongs of the exemption, going to the duties performed, whether she performed exempt duties more than half of the time. So at trial, by a split vote of 9-3, the jury rejected the franchisee's executive exemption defense. And the franchisee appealed on the basis that the verdict form question was too narrow. And the court actually determined that the question was unduly restricted. And what they found is that with these ultimate fact questions, the questions must present conclusions of fact. And they must be presented in such a way that nothing remains for the court but to draw conclusions of law. Basically, what the court found was with the first question, what was happening is that, yes, it hit certain points of that first, or one of the points of that exemption, particularly the quantitative aspects, but it didn't kind of fit all the considerations that go into that exemption. For instance, kind of the realistic expectations of the employer and the realistic requirements of the job. So a question that the court said could have been asked was whether the employer proved that the employee had performed duties which meet the test of the exemption more than half of the time. And the court found that such a question would have been sufficiently broad enough to include the several matters the jury was to consider. Again, like I said, which includes the nature of the employee's duties, the employer's realistic expectations, and the realistic requirements of the job. So really the takeaway with this case, and again, it's not something you're going to think about every day, but just to consider is that with these misclassification suits, employers want to pay special attention to these verdict forms, making sure that the questions sufficiently encompass what the jury has to consider. And that is all we have for exempt employee status.
Well, to keep the plot line developing here, there's been a wardrobe change, as those of you present can see. I've now buttoned my jacket. I want to keep things interesting. I know those of you are appearing, remotely. You don't get to see some of these developments, but incentive to come in and watch the show live. We had a question come through during one of the presentations about whether there is a minimum salary requirement for the FLSA, not just California, whether the minimum salary requirement only applies to California employees. Anyone know? Anyone in the audience? No attorneys, you don't get to answer. Yes, it is, but it's a lower amount, but it also applies for out-of-state employees as well, as is typically the way, right? Higher floor here in California for most regulations. Now we're going to move on to star player of the hour, the National Labor Relations Act, which most of you probably ignore because you sleep well at night knowing you don't have unionized workforce, right? Everyone thinks so. The NLRA doesn't apply to me, right? That's kind of the common sentiment. But Section 7 of the NLRA actually reads as follows, and everyone should pay attention to this. It guarantees employees the right. Apologize for me walking back and forth. It's like a cartoon, right? They walk in circles. I guess I do that. But it guarantees employees the right to self-organization and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So, unbeknownst to many employers, the NLRA applies to all workforces whenever there's employees, as long as the employees are engaged in concerted activities for their mutual aid or protection. So think of how broad that could be. So if an employee is complaining about their work, it's not safe here to work, right? And then for me and my employees, or if they go and complain about their pay, right? That's considered protected activity under the NLRA, whether or not you're unionized. So again, this is something I think a lot of people realize. And to be honest, a lot of the plaintiffs bar doesn't bring this when they can. But we'll talk about how they're maybe wising up to this. In very small text, let's take a moment everyone to read this, okay? Everyone's done that? This is a case, Boeing. This is back to 2017. This is an NLRB case that came out. And this is during the Trump administration. And this deals with it says the NLRB instituted a general classification scheme for facially neutral workplace rules and regulations that interfere with the exercise of rights protected by Section 7 of the NLRA. So think about all the policies we give to our employees, right? All the various, you can do this, you can't do this. So the question then becomes, to what extent are we restricting their ability to engage in this protected concerted activity? So traditionally, Lutheran Heritage Village case in 2004, this is what kind of governed. It was essentially a case-by-case analysis, meaning the NLRB would look at these policies on individual level. And ultimately, the determination as to whether it violates Section 7 of the NLRA was, even if it was facially neutral, meaning it's not specifically saying you can't do this as a group, you can't complain. It seems to be just kind of this, again, facially neutral policy. If it would reasonably be construed, the language of the rule, to prohibit union or other protected concerted activity, it would be found to be unlawful. Okay, and again, the case by case being the key, meaning you could bring it and the court has to look at it under all the circumstances, whether it was violative of the rule. Under Boeing, in this case, it came out in 2017. I'm setting the stage for development that happened last year. I'm sorry to go back to 2017 here. But under Boeing, the ruling was that many workplace rules were declared presumptively lawful. So basically, if it was facially neutral, it was presumptively lawful. There's a few exceptions, certain parameters I mentioned here. But for instance, rules against disclosure of company private information. No camera rules or cell phone usage rules. Again, for years now, this has kind of been, they're presumed to be fine, even though maybe in some circumstances they could impact concerted activity. Social media policies, right? Someone goes on and complains about how unsafe it is to work at your factory, media contact rules. Again, you can see how these dovetail into potential protected activity. But under the old rule, it was considered presumptively lawful. Under Stericycle in 2022, on January 6, 2022, the NLRB issued an invitation for briefs regarding whether it should continue to adhere to the Boeing standard. And basically, this is what the NLRB does, by the way. They solicit briefs, they solicit opinions from everybody. Unlike courts that love to just render edicts unless someone tries to write in and add their opinion. They want to read the room to see what they should do here and how they should handle it. But the kind of general expectation is, given the new makeup of the NLRB, is that we're likely to turn back to a Lutheran heritage standard, this case by case, meaning that presumption will be withdrawn. So we're going to have a little bit more litigation in this regard. And again, you're seeing the neutral policies might be viewed as a little more problematic. So we're going to see this theme has, some of those slides will show you how there's kind of an increase in activity in this area. So under the NLRB injunctive initiative, under section 10J of the NLRA, the NLRB can seek preliminary injunctions. Everyone knows what preliminary injunction is, right? It's basically saying we can prohibit someone from doing something, even if they haven't done wrong yet. We think the likelihood this is going to cause irreparable harm is such, I'm going to stop them from doing anything, right? We're going to nip it in the bud. Discriminatory action by a company against a union organization efforts. So if an employer looks at them doing something that kind of smells a little bit like it might be a violation of the law, NLRB can say, look, you can't do that. We're going to stop it right now, even before it materializes into a violation, because it could have this impact that we don't want to have. On February 1st of last year, the NLRB General Counsel issued a memorandum basically announcing an expansion of this. Just, before, this wasn't used very often. It was only in very limited circumstances, in a very limited fashion. You didn't see a ton of these. But the NLRB is basically putting the flag saying, we're going to start bringing these more often, and in not such a limited fashion either. The NLRB will promptly pursue injunctive relief before trial on the merits, including consideration of many contextual circumstances, such as inherent impact, union support, and a local labor market, so that employers will be deterred and employees will enjoy more immediate protection in organizing unions, sorry. And this is an important thing to realize, not only are they barking, they're biting. So in 2022, there's been over 40% increase in the NLRB pursuing these type of actions. So something to be aware of. And following that theme, we're seeing, again, other more increased activity in unfair labor practices. A lot of you have had the benefit of not having to know what that means, but anyone who's ever been involved with the union realizes that's what follows. A ULP is basically a violation of this. They file it in the violation of the collective bargaining agreement or one of the NLRA rules. But in the fiscal year of 2022, union representative petitions, so companies and workforces seeking to become unionized, increased 53% from year over year, which is very significant. It's the biggest increase they've had since 2016, which, you know, that's not too many years, right? Since we had a big uptick a few years ago. But then if you look at ULPs, they had the biggest increase last year they've had since 1959. So again, you're seeing sites turn. If you know any of the plaintiffs bar, they tend to follow streams. They tend to follow, right? What's everyone doing? They look around. And so you can expect to see more of these types of actions being filed. And again, this increased by nearly 20% last year. And with that, we're going to turn the time over to Shauna. Yes.
We are, because we're actually amazing, a little ahead of time, we're going to take a 5-minute break, give everybody a second to stretch your legs before I bore you to death and scare you to death a little bit further before you leave. And then that'll also, I'm hoping, give the folks on the web time to formulate any questions they might have in advance of, you know, instead of waiting till the last minute, go ahead and stick them in the Q&A so that we can start kind of looking at those questions and we'll review them to address at the end. Okay, so before we move on to the privacy, which I will get to in a second, we wanted to just, before we like forget everything we already talked about, there was a couple questions we got at the break on some things and a couple questions on the web that we thought it might be helpful just to kind of just get through. So Ryan and I will split those up and try to get through those real quick.
So we're gonna go back through some of these, and good question that a very perceptive member of our audience brought up is, you know, and again, the hard thing about this is these are so legally dense. Right. So the question everyone has to figure out is, how the hell does this apply to me? Right. And unfortunately, a lot of this is like, well, it applies a lot to your lawyers, but it might not have a direct, you know, immediate impact on you. So just quickly, again, I know we went in depth in the Spiking River Cruises case and all this, you know, PAGA stuff and arbitration agreements. The main takeaway for you on what to do about this is make sure you're updating or you're having your attorneys take a look at your arbitration agreements. Right? There's not much else you can do about this one, but if you have an arbitration agreement that's not up to date, then courts will do all they can to not enforce it. Yeah. That's the one thing they're left with. So the key is make sure you don't give them that.
And not only that, it's not that your arbitration agreements were bad before, it's that before the law was the opposite. We had to exclude PAGA claims from arbitration. So all of your old arbitration agreements would say something like, this arbitration agreement doesn't apply to disputes that can't be arbitrated, including PAGA cases, because we didn't want the whole enchilada to be thrown out and be stuck in court. So what we wanted was the court to say, well, we'll save your PAGA case for later. We'll litigate in the arbitration, you know, private arbitration, your individual claims, and then we'll come back to the PAGA claims. Now, because of Viking River, that's gone. And so if you're still using your old arbitration agreements that say, accept PAGA claims, we're worried, and I think it's a valid one, courts are not going to force somebody to arbitrate something that that we said you wouldn't be forced to arbitrate, right? So we can't bait and switch them. And I had this come up, unfortunately that we settled the case, but I had this come up with somebody who said, well, at the time that I signed my arbitration agreement, I understood that I wouldn't be required to arbitrate my PAGA claim. And even though we had like a savings, there's a sort of a savings clause in there that said, you know, under applicable law at the time, she said, well, when I signed this, in my mind, I would still be able to bring my rights as a PAGA claim. Now, no individual employee would ever come up with that, but her smart lawyer did. And so we had to, you know, duke it out, and you know, I beat him because I'm bigger and stronger. No, I'm kidding. I say things like that from time to time to make sure everybody's following along. But really, the point is, we want to have we want to get all those claims into arbitration to prevent that one person. I'm pointing at Ryan, he's not that person, but we want to prevent that one person from being able to sweep all of the current and former aggrieved employees who's worked for you for the last year into the case. So hopefully that's sort of the practical, you know, reason why Ryan's saying update your arbitration agreements.
Yeah, this case in particular gets pretty wonky. It goes into the weeds of like the severance provision at the end, right? And how does that work? So again, it's really make sure your lawyers are looking at this. That's going to be really important. So that's the main takeaway.
We have a question here before you go on.
Oh yeah, I think just as a blanket general statement, thank God we have you on retainer. until 45 years ago. I still don't know what PAGA is. Basically, be your own attorney general.
Yes, yes.
It's so weird. It is.
Yeah. You know, FAA, I kind of get, you know, but when you start talking, this all might be in Chinese for me. I'm just,
Well, and
but I like hearing from you guys. It's great. and the food's really good. And you're missing out. There's a lot that goes on. And again, as a small business, I mean, you're basically saying that 2-3 of our employees can go, you know what, we want to be a labor, we want to have labor. And I'm going, you idiots. You know, you can't, there's just mom and pop. And that's it. But you're saying they can.
Well, that's what's crazy is they don't need the consent of all of them.
Yeah, they just need one person to bring it, and even your best employees, even those of you in this room who are the HR director, if you're swept into the types of claims that they've asserted, you don't even get to opt out. You know, you're just part of this aggrieved employees. You're aggrieved whether you know it or not, as it turns out.
Yeah. And so we'll quickly go through some of these. The point is, what do you do? I'll try that quickly. You know, a lot of it is, you know, hopefully your attorneys are handling it, but just things for you to queue up and be aware of. So you get,
oh, sorry, I was advancing for you.
Oh, sorry. 8051, again, same thing for this. The point was just business as usual, keep what you're doing, but make sure at this point, you know, what people are generally doing is not making them mandatory, right? That you have to sign arbitration agreement as a condition of employment, right? But, you know, we're not giving legal advice generally here, but, you know, that's the big thing is how do you issue these? Do you make it, what do you do with employees who refuse to hire them? What do you make this specifically called a voluntary agreement? You know what I'm saying? These are things that we're giving advice on how to handle that. But that's the only issue here is, do you make it voluntary or involuntary, and to what extent do you do that during the time when this AB 51 issue is moving around? PAGA manageability, stuff you don't need to worry about unless you're in a PAGA case. Exclusive concurrent jurisdiction, don't need to worry about unless you're in a PAGA case. And
independent contractors, hopefully this was pretty straightforward. Any Romano, we have a question?
I was just going to say, Ryan, you said if anybody's in a PAGA case, is anybody here involved?
We have a couple, but they're hopefully being guided by us. But if they are not, and if you have questions, you know, with respect to your specific issues, feel free to bring that up if you think it's for the good of the group, or we can chat afterward as well.
For sure, yeah, feel free. The best question is a dumb question, right? I don't know what you're talking about.
Yeah.
You know, okay, great, you can clarify, because we have we talk in Latin sometimes in the law.
Okay, the next question was on the fleet vehicle thing. If you want to just jump to the aisle right here. Okay, so the fleet vehicle device question is sort of, so I guess to summarize the question, it's really how does this work between the sort of push me pull me is we want to monitor our fleet vehicles because we want asset protection. We don't want the fleet vehicle to disappear in the middle of the night while it's parked in front of somebody's house. And yet, on the other hand, we're being told, you know, employees have this right of privacy and we can't monitor them and what they're doing. So the fleet vehicle technology that this law, AB 984, specifically actually addresses is narrowed and only limited to these alternative devices. Now, as Rachel said, there's not a great definition of what an alternative device is, but if you read this very dense, 27-page explanation of the law, it appears to apply to these digital license plates or technology that we don't even maybe have yet. So the DMV is actually piloting these digital license plates, which are like a sticker you slap on your car that is digital and provides and contains all the information that a license plate would give if a CHP officer were to like manually type in your license plate. Instead, they can just scan it and it probably tells the toll, it talks to the toll transponders and all of that. So those devices are what you have to make sure you're not using to monitor employees after hours. And you have to make sure that if you have those on your fleet vehicles, they're either turned off after hours, and if they're on during working hours, you need to have a strict understanding or a statement of what it is exactly that you need this tracking for. What is the business purpose of why you are tracking what these people are doing? And you need to notify them if you're, just tracking their location, or are you watching them? Are you listening to them inside the car? Are you surveilling them in some way? Okay, so that's the rub. the question on sort of like, what's the best thing to do given the sort of very fuzzy definitions of alternative device in the statute, because it's not really defined. Does it include other types of GPS devices like a tablet or other tracking apps that you might have? And so the main thing that I think the takeaway here is, number one, don't track your people, track your stuff, right? We're tracking the vehicle. That's, we want to make sure we know where the vehicle is. Is it on time? If it's a FedEx independent contractor that's, you know, driving around on a route, where is the vehicle? What happened when it got in a car accident? How fast was the driver going? Were they braking? Whatever those things might be. If it's a vehicle that an employee is a service person and they take their vehicle home at night and the vehicle doesn't show up in the morning, we'd like to know where it went, of course. So track the vehicle, not the people. And then if you do use the alternative license plate or something that, you know, maybe later gets better defined, make sure you give them this 8-point notice that Rachel talked about. And then be mindful that another penal code, like separate from this new law, is an old law that says that you can't use a GPS electronic tracking device to track the whereabouts of a person. So again, that means without the consent of that person. So you either need to get consent of the person or you need to get the consent of the vehicle owner. So you're the vehicle owner. And so typically you consent to yourself. Best practice, probably also get the employees, you know, notify them, let them know that you're going to be doing this, put it all in writing. And then to the extent that it's practicable, turn off and shut down things after hours. If all that means is you just leave the basic like GPS, maybe you just leave the GPS monitoring on, but you turn off all the video and audio and everything inside the vehicle, allow the employee to sort of click off and shut down, especially because, you know, now they're driving home and they may really need to pick their nose and they don't want to do that on camera. Okay. All right. So hopefully that clarifies kind of how this all kind of works together. Any other things we need to clarify on the old stuff before we run on? Yes, please.
I just have one question about the like the meal period.
Okay.
It's considered wages. Is the hour considered hours for purposes of benefit eligibility?
No.
Profit sharing?
No. So if you pay a premium, it's like a freebie for the employee, but it doesn't count towards overtime. It doesn't count towards the hours worked for paid sick leave or CIFRA. It doesn't count. Let's escape out of the. Ramona, it's frozen.
Oh, there we go.
Oh, it's coming along. Okay, I won't mess with it while I'm talking because that seems to be the problem. Yeah, so no, so it's not an hour of work. It's just a premium because they missed it. They missed the period. Okay, so now we will try to quickly get all the way down to employee privacy, and I'll.
Okay, just jump in real one
Yes.
last question.
Yes.
The employee says, you know, I'm so busy, I've got things going on, I don't want to take that half hour, I don't want to take that 1 hour. You literally have to force them to take that hour because they'll come back and haunt you, or
You don't have to force them, but there's several options you could do, right? You could penalize them, you could discipline them, right, for not doing it. You could terminate them for not doing it because the company policy. But under the law, we don't have to police these things, right? Technically, but we know, as a matter of fact, once it gets to litigation, you don't want to have that question mark hanging out there that they can sink your ship with. So one thing you do is have them sign a document saying, I took this, I was told to, but I decided not to. It wasn't
voluntary.
A business requirement, right? Some sort of authorization, you get that, you sign it. I was given the opportunity to take my break, I chose not to take it.
you could literally have just a generic form in the file cabinet and just hand it out and be
Talk to Lucas, yeah, we have forms for employees who miss breaks and they actually authorize, and you create a record internally. Every time you get a missed meal or rest break, they can say, I did this because of which reason. And if they said took it because the business was crazy, you know, we had tons of customers come in and I had to miss my break, then they sign that and you give them the premium, you know. But you're keeping a record of why that was the case. You know?
You have to leave them free to take the break. You can't interfere with it. I'm going to take the clicker away from you. And then yeah, if they choose voluntarily and they can admit in writing that they chose voluntarily, the only caveat I would say to all of that is once you're in litigation with somebody, all bets are off. Suddenly that person was told to sign the missed time form by their supervisor and they were told that they couldn't take their meal period and they were pressured with a gun to their head to say that they wanted to take it on skip their lunch and they really didn't want to. So there's always people who are going to say whatever they're going to say. So there's no like foolproof, bulletproof, whatever, but the more evidence we have, contemporaneous evidence at the time that yes, indeed, this person chose to take a little bit later lunch because that's when the taco truck was coming to the job site or what have you. I mean, I've heard it all. We just want contemporaneous voluntary confirmation. There are, like Brian said, we have, forms for that, of course. So, okay, I'm going to now switch gears. If you have more questions that came up for anything earlier, feel free to, ask at the Q&A. If you have questions as I go through and you're sitting here and I'm talking to you and it's like Greek, raise your hand and I will try to simplify it as much as I can. So I'm going to talk about the California Privacy Rights Act. Some of you, if you're a small business and you have less than $25 million in revenue and you don't buy and sell people's data for a living, don't have to worry about this, so you could sort of tune me out. However, I think it's good to educate yourself because we always start sort of with the big businesses and then it all kind of like eventually trickles down to everybody. So I would say, listen and follow along, but don't have any heartburn just yet. If you are a bigger business that has $25 million of revenue, meaning last year in 2022, you had it, then this applies to you this year. So it's every calendar year you look and say, what was my revenue? Or are you the kind of person that processes a whole bunch of you buy and sell people's personal data? Okay, so that's what the California Privacy Rights Act covers. It took effect in 2020. However, we didn't have regulations. We still actually don't have regulations. What we finally have is 73 pages of proposed regulations that have been going through the drafting process and the comment and review process for 2 years. So almost 3 years, right? So we are now in January 2023. It is January 11th. And these regulations, the law took effect with respect to employers, January 1, 2023, and we still don't have final regulations. The final draft of the regulations is out and being processed, and we hope that we'll have them soon, which then we will be able to sort of generate kind of template notices and things like that for those of you that this applies to. But until then, we're all sort of left guessing, and I'll have some advice for you on what to do there. Not legal advice, but practical advice, right? Because I can't give you legal advice in a seminar. Okay, so most of the provisions under CIPRA that weren't already up and running started January 1st, and they look back. Some of them have a look back of the last calendar year, which goes back to January 1st of last year. And what does this mean? It means that a business, if you're one of these bigger businesses, will have to disclose certain information, and consumers all over California, including all of you as individuals, will have rights with respect to covered businesses about what happens to your personal information and your sensitive personal information. And I don't need to define that just yet. I have a slide on that in a bit. But the big thing for you all to know, all the employer and HR folks in here, is that there were a bunch of exceptions baked in that were sort of postponed for employers because of the concerns about, well, are these people consumers, employees, applicants, emergency contacts, beneficiaries under various, health insurance or life insurance policies, independent contractors, members of boards of directors? All those people are consumers. So what they did was they said, well, we'll give you 3 years while we come up with these regulations to get, up to speed and get ready for what you do. Of course, we still don't have them. But in theory, this law did take effect January 1. However, enforcement will not start until July. And so between now and then, we're all in kind of limbo, and it's sort of like, do your best to comply as much as you possibly can. And as the regulations are finally finalized, then start complying with the actual regulations. So like I said, the last round is like up and in process. The agency is considering further modifications. They understand the urgency of this, but we're hoping for like late January, early February for these regs to come out to tell us exactly what some of the things mean in the CIPRA, because the CIPRA itself is long, but you need 73 pages of regulations to explain it. So compliance begins July 1, and at that point, the Consumer Protection Agency will have the authority to then issue orders to non-compliant companies to stop violating the CIPRA. And they can impose fines of $2,500 per violation. And then if it's determined to be an intentional violation, up to $7,500 per violation. Now, if you can imagine, if you have any data whatsoever on any employee, which you all do, you can imagine how excited plaintiffs' lawyers are chomping at the bit to start, hoping that they can maybe do a private right of action, or hoping that these things will come up. And we can certainly imagine, the wonderful lawsuits that are to come. So again, don't stress unless last year you had 25 million in revenue and you buy, sell, or share the personal information of 100,000 or more consumers or personal data. Now, you see all these ors, right? These are not and, so 1, 2, or 3. So if you fall into either of these 3 buckets, you are covered. And that includes people who are smaller for-profit business that derive at least half of your revenue from selling or sharing the data of California residents. Now, I don't think that applies to any of you, but if you think it does, let me know. But most of our clients are not engaged in selling people's data. Some of our clients are larger employers and do meet these other thresholds. So the other thing to know here is you can be brought in scope if you are like a part of a larger business that has common ownership. You share the personal information with your parent company and you have like common branding. And so, parents and subsidiaries can all sort of be bundled together for purposes of deciding, are you covered by this law? So be aware of that if you are a subsidiary or you're a parent and you have a bunch of subsidiaries. So what are the rights and obligations that people have? Well, there are a few. One is the right to know. I, as a consumer in California, can ask a covered company what personal information they collected, sold, or shared about me. And this is that look back I was talking about. I can ask you what you've done with my information all the way back to last January. So that's not such a humongous deal now, right? When it's only 1 year out and businesses presumably could figure that out. It may be more difficult to know if you're 5 years from now, what you've done with my information. So this is where document retention and destruction policies are worth considering updating, because you don't want to maintain stuff you don't have to. And if you've got a bunch of things that are sort of in your ether, in your internet, on your computers and in your files that are well past the time when they need to be saved for any other reason, it's something to think about. What do we need to do with the data? Do we really need to hang on to all this data, or can we streamline what we have and just keep the bare minimum? That would be a great project. Hopefully, we talked about this a little bit last year, and hopefully some people took us up on that suggestion. But if you haven't, certainly now is the time to figure out what data do you really need to keep, because if somebody asks you, what have you done with it? You have to respond to that within 45 days. You have 45 days to figure out what of their data do you have and what have you done with it. They also have the right to correct inaccurate information, and you have to respond to a request for correction within 45 days. Now, before HR people all go, oh my gosh, I can just imagine somebody getting a personnel action or performance evaluation and saying, my manager was wrong. I didn't fail to turn this in on this day. I turned it in on that day. And God forbid. So no, that is not what we're talking about here. This is, number one, information that you collect from the consumer. So this is information they give you. You gave me your name, address, and social security number. And it turns out that your social security number that I wrote down was wrong. You have the right to tell me, hey, you got to correct that. You have 45 days to fix it and respond to me. So that's objectively false, wrong information that you gave me that I have to correct. Okay. So it's not my performance review that I disagreed with. I don't get to fix that, unfortunately, for those poor employees who always disagree with every personal action. So this is, again, related to specific pieces of personal information that we've collected. And then also they can ask you, what information have you sold to what categories of other third parties, and who have you disclosed it to? So you need to know what third parties you are disclosing your employees or other consumers' data too. So you need to make sure your vendor list is kept sort of up to date. And I would recommend some kind of a spreadsheet if you change vendors so that everybody knows, oh, we switched from ADP to Paychex to, you know, Gusto to Paylocity. And these are the dates that each vendor was in sort of in possession of this data, right? And that's helpful anyway, whenever we get a record request and people are asking for their wages and, you know, we're like, well, you know, we used to have Gusto, but now we have ADP. And when was that? Okay, so it's nice to sort of know when you had what vendors. And then on top of that, they have the right to limit the use and disclosure of sensitive personal information, which I'll talk about in a minute, and to opt out of you selling or sharing the sensitive personal information if you're the kind of business that does that. And so this is an opt out. It's not an affirmative obligation that you have just automatically. It's somebody can write to you or click on a link on your website and say, limit the use of my sensitive personal information. I'm going to define what all these things are in a little bit because I think the overview is more important, and then I'll define these terms of what I'm talking about. So businesses have to delete also, another right is that they have to delete personal information upon request. You have to also notify any service providers of that request. And so again, this is information that they gave you. It's not necessarily information you collected on your own. In fact, it's not collection like your background checks that you might have gotten on an employee. You didn't get that from the employee, you got that from your own sources. So that's not covered. And that's in the slides, so you don't have to worry, it's covered. But I just want to make sure we're all on the same page as I go through kind of what this is overall. Yes, ma'am.
So like I get notices from ADP when applicant wants to delete their application. So that's
covered, right? Because that is something they provided to you. I provided you my application, you decided not to hire me, and now I want you to delete it. So, but if they, let's say they authorized you to do a background check and you got a fingerprint, and a you know, a criminal background check and a driver history or what have you, that's information you collected from other sources. Did I have a question over here?
Well, I was just gonna say, depending on, I guess it's part of the not would be the difference to the HR record.
Yes, so there's our exceptions to that. So yeah, so good point. So if you didn't hire them, then you have no reason to hang on to that application, unless there's a business reason why you have it. And so you don't always have to delete all the information that they ask you to. There are exceptions, and I'm literally about to cover that. So I'll cover that right now. It's like literally right here. Next bullet down. So there are some industry-based and other exemptions. So for example, an educational institution does not have to comply with a student's request to delete their grades or their test scores, right? A financial institution that's collecting personal information like to get a loan or other personal, family, or household purposes, they don't have to delete your information when they've collected it for those purposes. And likewise, if you collected the information and you have a business reason why you need to hang on to it, like to prevent fraud or for security reasons or something like that, you can hang on to the information. So there are exceptions. This is where, like, call your lawyer, because there may be an exception that applies. I'm not going to be able to cover like every single nuance of this, you know, massive quantity of regulations in half an hour. But if you have a legitimate reason to hang on to it, there are exceptions that do apply. So there's a few of them. So, but good point. So, and again, this is only personal information collected from the employee, not created by the business. You created this yourself, or you collected it for others from other places. It's not subject to their deletion request. This is your information, not theirs, right? So you can refuse a request to delete if you have to comply with other laws. So this is to your point. If I have laws that require me to maintain human resources files for 3 years, then I can't delete it because I have to comply with this other law. So retention of records under whatever laws may apply, tax laws, you know, laws to retain payroll and personnel files, that kind of thing. But that's until the limitation period ends. After that, let's say 6 years went by and somebody reaches out to you and says, you know, I used to be an employee of yours and I want you to delete my personnel file now. Well, if it's well outside the statute of limitations for any objective reason why you might need to maintain that, then you should comply with that, because you don't have to maintain it anymore. There's no law that says you've got to maintain somebody's personnel file forever, even though it may live in your system sort of forever. So that's, again, where these document destruction, something that triggers, hey, these files are due to be deleted. It's been, 7 years. There's no possible reason why we need to hang on to them anymore. But if you're going to have a plan of destroying documents, you want to have a policy, a written policy that you're complying with, and not just do it ad hoc, because you have to explain, maybe you may have to explain yourself in other contexts, like, why did you delete that? Well, if you're in the middle of a lawsuit, definitely don't delete anything. Okay. So, all right. So if you have to maintain integrity and security, if you have to comply with other laws, if you're in the middle of a lawsuit and deleting these files would prevent you from defending your claim, you don't have to delete the information, even if you got it from the employee. So another obligation for employers to be aware of is that when you're collecting information, this is going to be from your job applicants and your new hires, particularly, you're going to need to provide these notices at collection of, there's a few things that are specifically required by these notices that you have to explain what types of personal information and sensitive personal information are you collecting, and why. What are you going to do with it? And then state whether, as a rule, your business is in the business of sharing or selling this kinds of information, and how long the business expects to retain, or what criteria might you use to decide. So something like, for applicants who don't get hired, we typically would, delete your application after 90 days. For applicants who do get hired, we have to maintain, for the purposes of, HR compliance, we'll maintain them for at least 4 years, whatever. And then there needs to be a link. So if this is online, you have a link to a notice of the right to opt out of selling or sharing your personal information, if it will be sold. If you say that we won't sell it, then you don't have to provide a link, because that's not happening, right? So, and then if you are collecting this by phone, let's say, you can give a verbal notice. So if you're calling somebody, your HR, you've made a job offer to somebody and you're asking them questions to sort of plug in to whatever you're plugging in, and you're on the phone with them, you can give a verbal notice at the time of collection. And I would have a script prepared for whoever it is that has to give these notices, so we make sure we hit all the reasons and that they give the right answers, because I don't know that just sort of every person that might have to give this notice would know what to say, right? Wouldn't even know the answers to those questions. So a little script would be helpful. And then if you're collecting data in print, like offline, you're hiring somebody who walks into your restaurant and they fill out a paper application, you have two choices. You can post your notice about what you do with personal information somewhere where they can see it, or you can hand it out as a piece of paper. So, and either way you slice it, you've got to give the notice, but there's options how you do this. I would just say, if you're going to do it as part of an online application or your paper applications, just slap it right on there, make it, the last few pages of your form. And then also double check your privacy policies, whether that's in the handbook or in some standalone, your terms and conditions on your website, and make sure that it's up to date with respect to how human resources data is being used on and offline. Most employers that fall within this CIPRA requirements updated their privacy policies a couple of years ago when this CIPRA took effect, but because there was a sunsetting of the HR related regulations, it's worth double checking to make sure that we added what do we do with human resources data about our employees, applicants, independent contractors, anybody else who might have been sunsetted until now. Okay, some tips, and I know I went through that quickly, so you're all seemingly like you're following along, but if there's anything you want me to stop and kind of get into the weeds on, I can. I think I failed to, did I talk about the slide? Oh, I might have not. Here, let me just skip forward real quick. I think this is slightly out of order. I want to define for you what I've been talking about all along. So personal information, that just means something that identifies, relates to, which is very vague, describes, or is reasonably capable of being associated with, or could be linked directly or indirectly to a particular consumer or household. And you can probably see why I didn't start with this, because this is like mind-boggling. And this is one of those legalese questions where like everybody's head explodes and goes like, what does this mean? Like, I mean, it's basically anything that if like we played 20 questions and I could guess that we're talking about Rachel Davey, maybe that's personal information. You know, the blonde attorney from San Francisco who was wearing the black dress. Well, that identifies Rachel. I mean, you know, you could guess. So I'm pretty sure it's not meant to be that vague. And hopefully the regulations, when they're adopted, will be much more specific than this. But generally speaking, that's what personal information is as currently defined in this terrible statute. Sensitive personal information, which is much more of a concern, is well defined, at least at this point. And it applies to things like your driver's license, your passport, your payment card numbers if somebody provides you with their avoided check for direct deposit that has all of your financial banking information on it. Going back to our fleet vehicle tracking, your precise geolocation data. So where I am in time and space, if you're tracking that about me, health, genetic and biometric data, which probably employers aren't generally collecting on their employees, but you would certainly be collecting if you're a healthcare provider. Race and ethnic origin, religious and philosophical beliefs, union membership, whether or not you're a member of a union is sensitive personal information, and the contents of any resident's mail, email, or text messages, unless they sent it to you. And so if they mailed you something or you mailed them something, or you're exchanging text messages with the person, that is not sensitive personal information. But if you've obtained it from another source, you've obtained it somehow about them, you opened their mail, you pilfered through their emails and found personal emails, in their work email, those would be considered sensitive personal information. And so generally speaking, all of you California residents have the right to request that businesses stop using your personal information, your sensitive personal information. There's 8 exceptions to this. The big ones I've listed on this slide. Basically, it's if you give me your personal information and I'm trying to perform a service for you, I'm your doctor's office or I'm your therapist or what have you, I'm your lawyer, you've provided me information so that I can help you, that's excluded. You can't stop me from using the information to help you with it. It brings to mind Jerry Maguire, help me help you. And then another exception is to prevent, detect, or investigate, fraud or security issues. To resist hacking, malicious attacks aimed at your business, deceptive practices, and then ensure somebody's physical safety. And then if you have quality control, mechanisms. So there's 3 more that I didn't list because I didn't think they would apply to any of you, and I can't remember what they are off the top of my head, so don't quiz me, but I can certainly look them up if anybody's wondering. But if you do process sensitive personal information outside of those purposes, just what you need to do is post a link. This goes back to that opt-out I mentioned earlier, to limit the use of my sensitive personal information. And that allows the person to click the link and say, I don't want you to use it. Okay, so general kind of tips for now. So if you have not already started this process, update your, evaluate rather, what personal information you've been collecting for the last year and what personal information you're going to continue collecting. I would evaluate, do we really need to collect this information about these people? What do we do with it? Especially with regard to your applicants and personnel. So narrow down what you have if you can. If you're collecting extraneous data, you don't really do anything with it, chuck it, or don't ask for it, and then consider what are the uses, and identify every way in which you're using this information from people, and then develop some protocols around how are we going to handle and respond to data access, deletion, correction, and portability requests from our workers. If somebody asks me to do this, I have 45 days. We should not be figuring this out after we've gotten our first request. We should already have a sort of a plan in place. Who's going to be in charge of this? Train your HR and your compliance teams. If you have privacy people already, that's great. Work with your IT folks to sort of help you figure out what do we have and where is it all stored. And then I mentioned this already, review your data retention and deletion policies so that we can limit the amount of information we have to sort through and provide to people, down the road as these requests get made. Another key thing is review your agreements with your third-party vendors and make sure that if they are collecting personal information, that they commit to complying, obviously, with all of these requirements as well, especially a huge vendor like ADP that's going to fall within this, data collection law on its own. They were already, I presume, well aware and complying, but maybe your smaller vendors that may not be covered by CIPRA, they may need it spelled out for them. And so talk to your, lawyers that look at your commercial contracts. We're happy to help you with making sure it has information in the contract to both notify your vendors and ensure that they're required to comply. And then, if you don't sell or share personal information with them, just say so, right? Like, let's just come right out and say in the contract, we are not selling or sharing any personal information about a consumer to you. That kind of narrows down right off the bat. Like, we can strike that vendor off the list because we're saying in our contract that we don't do this. And then be aware that anti-retaliation laws, of course, apply just like everything else in California. If somebody complains to you or exercises their rights under these acts, then they cannot be retaliated against, and that's the enforcement that's going to take place starting in July. So those are the big takeaways, and I think I covered that. And before I move on to the federal analog that is percolating, does anybody have questions? Go ahead.
So we're a school. We are not big enough to fall under the CIPA, but we have a vendor that we work with that we do share PII information with that is based out of New Jersey.
Okay.
So this is a California law, not a federal law.
This is a California law. No, it affects California residents. So even if they're in New Jersey, they're covered by this if they collect California resident information.
Okay. So I should.
You should make sure that they're aware, look at their contract, and also make sure that they're aware of their obligations to comply. If they're a big, huge company, they probably are. Okay. The sales forces of the world, are well aware. I mean, they're also based in California, but the big, huge companies that do process data for a living, I'll say, they're aware of these rules, but certainly smaller vendors that may not be, just make sure. They also might not be covered if they're small and you're small. Everybody might be too small to cover, but look, like I said at the beginning, I expect all of these things to eventually work their way down to, smaller and smaller businesses as everybody gets their arms around how do we do this, and everybody kind of gets, up and running. And they always start with the very big businesses because they figure they have the resources and the money to figure all this out and get compliant. And then once that's sort of established and we're all used to how that works, it starts to, trickle down. So I think we should all be worried about this and planning for the future. And then all of you as consumers also have these same rights. So, you get to learn something about your own rights today. All right. So I'm not foreclosing other questions, but just in the interest of time, I just want to make sure I cover this federal law that because they're jealous of California and how fabulous our CIPRA is, the American Data Privacy and Protection Act has been introduced. It was introduced last June in the House, but it had overwhelming bipartisan support. Wow. So, the EU has already had their European Union privacy laws in place for a long time, and California's had some, and there's other states that have, piggybacked off of those. But this would create a national standard and safeguards for personal information collected by companies. And as currently drafted, it would preempt California law, which would allow all of us to breathe a sigh of the relief, because then we just have to comply with one set of laws for, hopefully everybody. But of course, that is a big bone of contention with California legislators who have worked very hard and spent a lot of time already on our law, and of course think it's the best. We all have our doubts about who is better at drafting legislation, but certainly California is going to be the most protective, followed only by like Sweden or something. But California, has already invested a great deal in this. And so I wouldn't be surprised to see the federal law heavily borrow from things they like about California and maybe, discard the few things that just don't get bipartisan support, that just seem too onerous. And it may be that this national law provides coverage for smaller employers, but then we still have the CIPRA overlay. So it remains to be seen, but it'll be something similar to how we currently have to navigate the FMLA, the Federal Medical Leave, Family Medical Leave Act, and this California Family Rights Act. Most they overlap and most of the regulations are consistent, and there's a few things. So hopefully if we end up with a federal law, it'll mostly be the same, and then we'll just have some weird oddities in California because that's California. But as drafted, it would preempt California law. And then the bill is expected to become a priority for 2023. So we'll be following that to sort of see how that goes and where that ends up. And with that, we actually have time. Historical moment here, folks. We have 12 whole minutes for Q&A, and I'll invite my colleagues to come up to the front in case the questions are things that they covered. And we'll take questions from the audience as well as anything that might be pending in the Q&A. And actually, I can look at it here, Ramona. Okay. Okay, so Rachel or Nikki, we have a question about exempt employees. So the exempt employee salary threshold that was discussed. Okay, you did cover that live. Okay, so yes, so the exempt employee salary threshold that was discussed earlier is California. It's based on California state minimum wage. So that's California. So that question was answered. There's also a question about the healthy workplace, healthy families paid sick leave.
That's what we said. So there was a question about the California Sick Leave Act, right? Paid family sick leave or paid sick leave act. That's going to be covered in our next presentation. So we're not going to get into that. We didn't really address that yet. So apologies to those who asked that question before we open up that box. That will be covered. I encourage everyone to attend. Yeah, so that's our pitch for you to please attend our next seminar and ask that wonderful question of our good colleagues in next week. And we hope to see you all there. Do we have any other questions in the room? Yes. Well, let's start here. You're up now. Oh, sorry about you. You pick up your sandwich, and I'm sorry, I mistook it for a wave. I apologize. Yeah, scared me.
So one is a clarifying thing, and then the other one is an actual question. So for the California exempt salary requirements, those do or do not apply to an employee working in another state but employed by a California company?
It depends on where their work site is.
Let's just say, for example, it might be New Jersey.
But is that do they have that's their permanent work location? You have an office in New Jersey?
We do not have an office. We do not have a physical location, but the employee works out of his home, fully remote. We only have physical operations here in California, but we have employees in like 21 states.
So there are factors that apply to whether or not that particular employee would or would not be considered a California-based employee. And in large part, it has to do with what you've said about the employee's work location and the contract and whatever else. And so if they were, I don't want to answer your specific exact situation because, we don't need to bore all the rest of them with your legal advice, but I'm just teasing. But hypothetically speaking, let's say that they during the pandemic, they lived in California, they reported to a work site here, and then they moved to New Jersey, and you allowed them to work remotely. Their job site might still be your office in California. And so you might need to, that may be a good question for you to sit down with whichever one of us normally gives you that legal advice, because that's a gray area. And it's certainly a possibility.
It's also state to state.
Yeah.
Some states are a lot more clingy, whoever's in their state.
We're very clingy.
Really care. California, obviously, we're on the clingy side, but
I'm pretty confident what we have right now is okay.
Okay.
He was hired there. There's never lived here. No
Yeah. So I mean, if you have a work location in some other state, or you have an office in another state, our salary exempt requirements only apply to California. The federal standards would apply, or whatever state standard there might be in New Jersey would apply to their salary requirements, and as well the test for exemptions. So the tests for exemptions in California are different than the federal tests as well. So just be mindful that you're applying, the right test and being consistent with those out-of-state folks.
So the follow-up question to that one is, how do we define a computer professional?
So it is not a help desk person. I know that. So
it's a very high-end software. If I recall, last time I looked at this years ago.
Yeah, it's like
it's fresh in your mind, but they're a high-end software developer. It's a lot more narrow than people think. It's generally.
Yeah, it's really like your head of IT certainly would qualify, but maybe not. But certainly not your low-level help desk people. So they have to be doing actual like program design or development. I mean, it's much narrower than what you might hope for. So if they're just like help desk, they're plugging things in, unplugging things, maybe they're, rebooting your computer for you, they're not going to qualify. These are These are highly technical people who would be the equivalent in the sort of software engineer world to like a lawyer, a doctor, you know what I mean? It's not meant to cover sort of your rank and file IT folks. Not that they're not wonderful and we can live without them, but
yeah, no, I'm
yeah,
with you on that.
Yeah.
Okay.
Yeah, so there is like a definition in the wage orders and a statute that actually it's I know, I know it's crystal clear. But I would just say, you know, err on the side of caution with exempt classifications, and the salary threshold is very high if you're going to make them salaried. So, you know, you might be able to pay them a lower hourly wage, frankly, and pay them by the hour, and then you don't have to worry about any of this. But that's a question for another day, maybe. Okay, another question.
There is a question which might be.
Okay, let me take a peek at it.
Why is the man jumping off the cliff?
That's a, you know, it's meant to be a metaphor.
We haven't
like now go into the world, spread your wings out, you know, apply all the wonderful things.
Yeah,
That's not what I don't know.
Okay, so the last question I'm just going to answer on the Q&A. It really had nothing to do with any of the topics we covered today, and I know that all of you have other things to do with your day, so I'll respond to that one privately to our web attendee, and thank you for the questions and your attention today. There's an outro that I'm supposed to give that I completely abandoned ship on Ramona, but make sure you, I think we usually just say, try to come to the next one on January 18th, and please do give feedback to us. I think that there's some sort of feedback form somewhere around here, or maybe it was emailed to you. I know that's really not what Ramona wants me to say, but okay.
And on the webinar, I did just realize that none of you received an evaluation form because everybody on the web got it.
Well, so you guys can just do a show of hands, thumbs up, or like, and we'll take it from there.
I'll hit our Yelp review.
Yeah. So yeah, so the next up is the employment law update on the 18th, and then following that we have waking up to discover your independent contractor was actually your employee. I love this title, The Legal Nightmare of Misclassification Audits and Lawsuits. So that ought to be fun and exciting. And for the person who asked the question about independent truckers, I would suggest you attend the March 15th seminar, because I think that's where we'll answer that question. But yeah, so there are lots more to come, and we thank you all for your time today.